All right. Hello, this is the Immigration Podcast. My name is Rob Ratliff. I'm an immigration attorney in Cleveland, Ohio. And with me are two other people. Uh, Susan, ladies first.
Oh, good evening. Susan Hiller, and I'm actually more interested in your case, Rob. So I'm waiting to hear about that.
Sure, sure. And also,
And I'm Nour Chamas, also immigration attorney in Cleveland, Ohio, but also practice in other jurisdictions.
e- excellent, excellent. Yeah, so I'll start out real quick by way of update on the Ayman Solomon case. We had detention and master calendar hearing yesterday. 2 hours before the hearing, DHS filed amended NTA on a 261 form and removed all the references to the terrorism bar in the
Hey,
amended
Rob.
NTA.
I know you know about the case, but for the
Yeah.
viewers,
Oh, yeah, yeah. Very
um,
good.
maybe you can start
Yeah.
out with the wonderful things he did and who he is.
Yeah. Yeah, so and for those catching up and everybody, Ayman Solomon is a imam. He was a chaplain at the Cincinnati Children's Hospital up until recently. He was granted asylum by USCIS back in 2018. He originally fled Egypt in 2014, and he had been working his asylum case. It had been granted. He'd been trying to convert to a green card as you're supposed to. That had been held up by DHS for 7 years now. In December of last year, they issued the notice of intent to terminate his asylum. They claimed he was had some supported a charitable organization that in turn supported Muslim Brotherhood, and the USCIS asylum officer determined that Muslim Brotherhood is a terrorist organization, despite nobody in the U.S. Having said that. So we're now in immigration court on this terminated asylum case. We the original notice to appear alleged that there was material support for terrorist organizations. It's just not there. There's been an incredible outpouring of support from the community, uh, faith leaders from all over have submitted letters in support of Mr. Solomon. Just things we've received from workers and families that have come in contact with him in his role there at the hospital. Just been incredibly supportive, and the allegations are that he worked for a local charitable organization. That is it. So, all these levels of assumption, but anyways, in that notice to appear, they took it out. They took out that reference, but then they turned right around and
They
said that
took
there's
out.
no.
Can I ask a question just to clarify? They took out the
Yeah,
reference. I believe you were telling me earlier to supporting a terrorist organization, correct?
yeah, yeah. They completely removed that from the notice to appear, and so we argued that there's bond available, and filed the bond request. The DHS resubmitted some of the same articles that the asylum officer had referenced in denying or terminating his asylum case, despite the fact that several days before we submitted letters from the authors of those articles saying that's not what my articles say. You're misconstruing what my research was. You're misconstruing what evidence has been submitted. So DHS just resubmitted those same articles and argued that there should be no jurisdiction, and the court's taking it under briefing. I was actually, before we clicked on here, working on my brief that I have to file before Friday to argue why there should be jurisdiction. I
And
think they're
so he
pretty
has
clear once you take out
he
those allegations.
What has
What's
changed?
that?
What has changed, Rob, since when he got asylum? Is there a significant change, country condition?
Po- Politics. I mean, and the weird thing about the politics of it is the termination was begun under the Biden administration. That was submitted to us or submitted to him and his attorneys at that time in December of last year. And then the final hearing was in February, and then the decision in June.
So, it it was it was submitted to you at a time frame when there was a conflict between Israel and Palestine.
Yeah,
Correct?
yeah,
Do
yeah.
you
And
think? And I know this may. I mean, I have to go down this road because the Epstein is in the news a lot lately, and I think if you've done your homework on him, uh, there is a military intelligence officer out there saying he was Israeli intelligence, and if there's blackmail in the U.S. government, and that's what's caused basically this administration to target Muslims, in my opinion, then, and maybe even the prior administration, because they had blackmail on Clinton, of course, which is widely known, and other people that perhaps that administration is trying to protect. Do you think that's why this could be happening as well?
I, I would hate to think that, and I think from our perspective, the important thing is that he just had no role in any of this. I mean, um, he had to flee Egypt because he was an independent journalist and came under threat during that really chaotic time in Egyptian history from 2011 to 13. Um, but there's no reason to suspect that anything at any higher level would be relevant to this case. He was just a local guy working in local charities.
Did you say that he was granted asylum in 2014?
Yeah, yeah. It was granted by the asylum office back in 2018.
Oh, 2018.
Wait,
What,
2018
did,
or 14?
or maybe he entered the U.S. in 2014.
He had entered on a B2 visa originally, so he had legal entry.
But he never
The
filed
only, the only
for,
basis for mandatory detention is the terrorism allegation, which they pulled out of the NTA.
and he never filed for adjustment.
He did. The adjustment had been pending for about 7 years when they finally did the notice to terminate.
So that was an APA violation, Administrative Procedures Act violation for all those years. I mean, they should have
What's
acted.
that, Susan?
An Administrative Procedures Act violation. They should have acted on it within a reasonable time frame. The way they and notified if there was an intent to deny way back then. In 20, you said he received asylum in 2018 or 2014.
He filed for asylum in 2015. I'd have to look. 2014, within the year, and granted by 2018. The green card application 2019, the year later, and it's been pending ever since.
So they never did an intent to deny way back in 2018 or 2019.
Well, yeah, and he's had other attorneys that have been litigating that over the years, and it's still out there. I mean, that adjustment of status is still pending. So, I mean, that's another, a pending adjustment of status is a whole other issue that may be pertinent to raise at the immigration court level.
And my understanding is that,
Oh, go ahead.
I'm sorry, that the information that they're relying on to make their allegation was actually available to them at the time that he applied for asylum, right? And he did disclose everything.
Yeah, I mean that's an important concern because nothing new, no new allegations in the decision for the termination. It's a 2-page document. I mean it's 3 pages if you count the signature, but it's essentially a 2-page document. The entire findings for determining that the Muslim Brotherhood, this huge, kind of loosely affiliated organization all throughout most of the world, is one sentence where the asylum officer says the Muslim Brotherhood has been a terrorist organization since at least December 5th of 2012.
So what's the basis?
That's it. Yeah, that's it.
No basis.
That's their basis. Yeah. Yeah.
They're
So
not listed
obviously
on
we're challenging that in the the articles they support it with. The authors are refuting that as well.
and they're not
Yeah, I
listed
think Nour was
on the
saying
State Department
they're not.
list of foreign terrorist organizations, right?
I believe they were taken off. I used to work with the Department of Homeland Security as an assistant chief counsel with ICE for 26 years, legacy INS too. So they were taken off of the State Department's designated terrorist groups, I believe during the Obama administration, because they were no longer designated. They were doing more community-based work, and they couldn't be said to be affiliated with the whatever was alleged before on the supporting such acts. So
Yeah. So I mean, and to label the entire group, I'm sure there's probably individual members that probably could earn that label, and I'm sure there's probably some offshoots that could earn that label. But it's such a large amorphous kind of entity at this point.
Now,
I don't know that that's.
what's the explanation that DHS is giving about them removing the terrorism charge in the NTA, but then still using it to argue mandatory detention?
None, and I try to, I've tried to argue that, and that's obviously something that we'll continue to argue. If you're pulling that out of the NTA, then what are you using as your basis to now argue that it still should apply with respect to the detention proceedings? Let's submit something other than a couple of articles that the authors themselves have refuted the way you've used them.
So what are they charging? Okay, so they tried to do a termination of the asylum, even though they already granted the asylum, and there's no material change circumstances or any fraud in the asylum application. So what is the removal charge?
Well, and right now the removal simply charges that the asylum has been vacated. So once there's no asylum grant from USCIS, he's in the position of anybody else whose asylum was denied. They said that they're getting referred to immigration court, and they're going to have a chance for de novo review there and a chance to reapply in a defensive capacity. So that's going to be the next step, and hopefully try to avoid that or try to limit the government taking a third swipe at this. But
Aren't they stopped from revoking the asylum based on the same information they granted it on already? Isn't that res judicata?
yeah, I mean, those are certainly going to be some issues that we're going to have, the immigration courts are going to have to deal with. Whether they can, the government can just keep coming up with new things and keep, well, we're just going to revoke. We're going to revoke now. Every time a new academic article comes out, that they can go back and revoke.
I don't know how
We'll
to
see.
declare the Muslim Brotherhood to be a terrorist organization when it's not on the terrorist list.
Yeah, that tier three stuff is very broad. It gives them gives DHS a lot of leeway to declare a group terrorist groups, supposedly on a case by case basis.
Right.
But I mean, that's a pretty broad brush to just say all all members of the Muslim Brotherhood, and the Muslim Brotherhood itself is a terrorist organization
Well, the
with no
Secretary,
specific
yeah.
allegation.
So they took off the removal charge because the Secretary of State has to designate it as a terrorist group. But they
Yeah.
are arguing that the Secretary of Homeland Security can use a tier 3 catch-all to override the Secretary of State's determination not putting it on a terrorist list.
I think that's going to be. I think at some point in the litigation of this case, that's going to be an interesting question. When can DHS overrule state or even uh, Congress, which has turned down several bills that have been introduced to declare Muslim Brotherhood a terrorist group. How that plays out.
I think it'd be very interesting to see how Marco Rubio voted on that in the past too, since he is the Secretary of State.
Yeah, yeah.
It's just
So Nour, what's new with you? I heard you won a few cases recently.
Well, I mean, it's up and down. Right now, we're dealing a lot with, obviously, a lot of bond hearings, um,
Yeah,
and dealing with the new DHS interpretation of Section 235 of the INA, basically arguing just about everybody is subject to mandatory detention because they are forever applicants for admission, even if they've been here for many, many years. They're now saying that because they're applicants for admission, they're subject to Section 235B2, which says that an applicant for admission, if an immigration officer determines that they are not clearly admissible to the U.S., that they can detain them pending removal proceedings. I don't read that section that way. I think it seems to me that it would clearly apply only to people either at or near a port of entry that are seeking to enter the U.S. No court decision has ever treated that section as casting that wide of a net. It just, basically can subject pretty much anyone to mandatory detention. Right now, their position is that 236A only applies to people who have been admitted to the United States previously, and it does not apply to anyone that has not been admitted because they are considered continuous applicants for admission, and therefore they're subject to mandatory detention under 235B2. But every case they're citing doesn't actually say that. They cite the matter of Cooley. Matter of Cooley is very specific and only addresses situations of aliens entering at, or either entering at a port of entry or being caught near a port of entry within a short time frame. Clearly differentiates that from people who have been here a long time. They're citing to Jennings' Supreme Court decision, which also doesn't say that. In fact, Jennings clearly differentiates between people seeking entry at a port of entry and those who have been in the United States for a long time. So, but the problem is that we're dealing with immigration judges who are employees of the Department of Justice, and so a lot of them are just kind of rubber stamping and going along with that interpretation. I had one judge on Monday out of Lumpkin, Georgia, funny enough, who actually agreed with my argument, said essentially that historically it's always people that have been here a long time have always been treated as falling under 236A, and now all of a sudden they're moving the goalpost. But he denied bond on the basis that there was no evidence that DHS made a custody determination, so he can't make a custody redetermination. Because he kept asking the attorney for the department, did we make a custody determination? And he would not. He refused to kind of answer the question. He refused to commit to it. And he said, and he kept saying it's not their burden, it's our burden. Which also didn't make much sense, because that would indicate that DHS can forever hold someone and never make a custody determination officially, like formally, and then they could never be subject to. They could never be eligible for the bond payment. So what I'm doing is filing a motion to reconsider, but the first thing I tried to do now is I actually emailed ICE in Atlanta to ask them if they're willing to release him. So if they answer and say, no, we're not willing to release him, then I can use that to clear the custody determination and file a new bond hearing with it.
So Nour, what's interesting about what you said is when I was teaching at the Federal Law Enforcement Training Center, the way we taught 235B was that they were applicants for admission at, and that would mean at a port of entry.
Right.
So, and I taught, over thousands of agents and officers at the Federal Law Enforcement Training Center for 6 years. And what's really important about that is the way that we teach, and we became accredited too. ICE got an accreditation in the program and everything, is that everything has to be taught the same way. And what's really important about that is the agents and officers, if they go outside of the way that we teach, and of course policy and procedures, then qualified immunity does not apply to them. So they have to be very careful. They have to adhere to what they're taught at the Federal Law Enforcement Training Center, in conjunction, of course, with their circuit decisions in their area. But so I guess I'm looking for the word. It's not confused, but I'm dumbfounded that they're having the officers and agents do something they weren't taught, and holding them and saying that everybody's an applicant for admission, because that's not the way that they were taught. And if you were to actually, you can FOIA the legal curriculum at the Federal Law Enforcement Training Center for that particular agent or officer, and you'll see the way that they were taught. And that's actually also buttress your argument that that is not the way ICE taught it to these officers.
Right. It's been that way for many decades. And this is the first time that they've interpreted that section in that way. And now all of a sudden, they're trying to apply it very broadly. So essentially, and that's one of the arguments I made in my brief, they're making Section 236A superfluous, meaningless, because they can always claim that anybody is forever an applicant for admission. Even if somebody, they're saying now that it only applies to people who have been admitted, but if you think about it, if later they can reinterpret it and say, well, somebody who overstayed and now is detained is a new applicant for admission. So now we're going to apply Section 235B2 to them also. But
that's legally incorrect.
It is. It's incorrect legally. I'm a little surprised. I wouldn't say too surprised just because I know how the system works, but still am a little surprised by immigration judges just going along with it. It's never been interpreted that way. No court decision has ever treated it in that manner. No BIA decision has ever treated it in that manner. And all of a sudden now, just out of the blue, they're just arbitrarily reinterpreting that section, and immigration judges are just saying, okay, that makes sense, and they're agreeing to it. And they're finding that they have no jurisdiction to grant bond.
Nor, I think they're being told, and I think you'll hear this from a former immigration judge that is a whistleblower that was just fired.
Yes.
They're being told to rubber stamp this.
That's how I feel. I have no direct evidence of that, but that's how I feel because of the way that they're handling these situations.
You're about to hear that soon as far as the detentions. These particular immigration judges are going to appear on CBS Evening News and NPR, and they are going to blow the whistle on how they were told at different courts around this country to go along with when DHS asked to terminate the cases, dismiss the cases, so that they could be arrested in the hallway. They were telling the judges to rubber stamp it.
So actually, I had this case that was a Brazilian case, and he actually failed to appear at his initial master calendar hearing. He was ordered removed in that case. He came to us. He happened to have hired these people who he thought were attorneys, but they happened to be some kind of notarios, but they defrauded him. They gave him wrong advice. They talked to him. He was thinking that he was speaking with an attorney, told him, don't go to the hearing that's coming up because they're arresting people. After the hearing, they just call us and we'll help you. So he didn't go, then he called them, and then they filed an appeal to the BIA, which is also the wrong thing to do because it's an in absentia order. The proper thing to do was to file a motion to reopen. So we asked for the case to be remanded. The BIA remanded it so that we can file a motion to reopen with the court. But he was in detention this whole time. So we asked for a bond hearing. Of course, their argument was matter of QE. He entered at the border. He was processed at the border. And eventually, he could not have been released except through parole, and parole is terminated now, so therefore he's under mandatory detention. So I went and I made an argument that he's actually not under mandatory detention because at this point, after the removal order, he can't be detained under 235. He would actually be detained under 241 because they're right now trying to enforce a removal order. However, once he filed the motion to reopen, that created an automatic stay of removal. And the automatic stay took it out of Section 241 because there cannot be a 90-day removability period when there's no removability at this point that's possible because of the stay. And actually there were circuit court decisions that supported that argument. And I argued that then he falls back under Section 236A, so now he's eligible for bond. DHS said, well, but he's still under 235 because of the way that he entered. And I said, well, 235 says mandatory detention pending certain proceedings. Those proceedings were completed when the in absentia order was given. So it can no longer be under that section. Now it's under 236A. The judge finally agreed with me and he issued bond. And then recently, this week I found out that same judge was fired. And I don't know if he was fired for that reason, but he was fired. He was actually based out of Massachusetts. The case I had was based out of Elizabeth, but it was
Who was that judge? Do you know that judge's name?
Nour Chamas.
Okay. I wonder, is he on probation?
He was, I think, within the probationary period because I looked him up and it looks like he was appointed in 2023.
Yeah, the fact that there's no judges, there's no dissenting opinions on that jurisdictional question, this completely novel jurisdictional question, and to a person across the spectrum, all the judges are just going along with it, certainly seems to indicate that there's some sort of directive.
Right.
Yeah, they're being pressured. They're being told they can be fired under Article 2. Even people who are supposed to have protections, basically as a public servant, civil servant, in the sense that it has to be for cause. It should be for cause, but the president or this administration is saying that they can just do it under Article 2 at will. And so they're putting the fear in even judges that are not on probation to go along, or potentially you'll be gone and you may not even be in the office able to go back in to get your belongings. They gave some people 15 minutes to go back in and get their belongings.
Oh yeah, without warning.
You got any of those cases on appeal yet, Nour?
So I have the one that I did file an appeal for the one that I had last week that was denied. That was in Cleveland. I have one that actually the judge granted bond. That was on July 14th. The next day, DHS filed a stay. But they haven't yet filed an appeal, it looks like. They have until tomorrow to file their appeal, or the stay will expire. So I'm hoping they don't file anything so I can get them out on
I
bond.
have a feeling they will, because I worked under Trump.
Yeah.
I worked under Trump 1.0, and we were forced to do things that, normally, especially as a senior attorney, I wouldn't think was a good use of resources. Like, for example, I had some cases that were DACA kids that one kid had an arrest for trespassing, and I was told to appeal the bond on that. Trespassing and his arrest, it wasn't even a conviction. So,
And that's fine, they can appeal it. I'm just hoping they'll forget to do it by tomorrow. So
they probably won't, because I'm telling you, I can imagine the pressure all of them are under, and I worked under the Atlanta office, and if Ryan Matsumi, the chief counsel, or Emily Reese, or any of the supervisors there want it done, the person will be, working their tail off to get it done. Probably at home, not getting paid tonight, because you don't get paid overtime.
Well, I was offered a DHS attorney position. It was like last year, maybe kind of year and a half ago, which I eventually turned down. I saw one of the DHS attorneys this week, and she actually told me that I dodged the bullet by not taking the job.
You did. I found it very difficult under Trump 1.0. And then I found it very confusing under Biden, because the policies didn't seem to really change as much as I thought they would, and too much discretion was given to the chief counsels on prosecutorial discretion, and Ryan Matsumi held up things, didn't want to grant things that should have been granted, and we were the messengers, even if we advocated for it to be prosecutorial discretion. So I just found it very frustrating. And right now, I would have had to have resigned, because I think it's unethical at this time. And I think, these attorneys, some of these attorneys are running the risk of violating their ethical obligations and as an attorney, never mind their oath to the Constitution of the United States. Because you can't just go along with what they're telling you to say as an attorney. It's different. If you know the law is, if that's not the correct interpretation of the law, you're not supposed to be, citing incorrect interpretations. Which I think is why Rob, you, and I also think you, Nour, are having problems with DHS articulating their arguments when they're outside of the framework of what they're told to say. Like, they don't really believe it. So when you really push them, they don't have legitimate reasons, because they can't tell you, my boss told me to say this.
Right.
Yeah, it's an interesting ethical question as to, surrendering your independent legal judgment, maybe at directive of non-lawyer supervisor at some point. You know, your direct supervisors in that chain of command are usually attorneys, but at a certain level, it becomes a political appointee who may or may not be an attorney.
Right. Fortunate.
All right. Well, that's been 35 minutes, guys.
I do have
We'll,
another event to go to.
See what it looks like and get it posted in a day or so.
All right, thank you. And Rob, if you think that Israel-Palestinian comment is going to get me on the terror watch list, you can edit that out. I am not suicidal. So if something happens to me and they claimed I killed myself, not true.
All right, we'll keep that in mind.
Yeah, well, duly noted. We'll keep the recording just for that purpose.
Thank you.
All right.
Appreciate it.
All right, guys. Good to see you.
All right.
Good to see you
Nice
too.
to meet
Talk
Nice
to
to
you.
meet you.
We're going to talk Tuesday, right? With
Yeah, the
a
judge.
very special guest.
Yeah,
All right.
that'd be interesting.
All right.
Take
Yeah.
care, everyone.
All right. We'll see you guys.
All right, take care.
Take
Good night.
care. Bye.